So Elliott, my husband and I are trying to get our papers in order, and we were going to get wills, and then someone told us that we should do a living trust instead. So what's the difference?
Well, a will is a document that says who gets what at the time you die.
Okay.
And it is only effective after death. And then it has to be admitted to probate, has to be submitted to a probate court, and then accepted to be what's called admitted to probate. Then it's given legal validity, and its terms are then honored. With a will, you have to file an inventory with the court of your financial assets, in which you disclose most of your probate assets to the court. With a trust, it's a different legal document. It's governed by contract law, and a trust can have effect at the time you create it. A trust can say, here's who gets what at the time I die, so it becomes a substitute for a will. But a trust also says that in the event I'm incapacitated at some future point in my life, that here's what happens when we name a successor trustee to manage our affairs, and you avoid something that's costly and burdensome to families called a guardianship. Now, some people will say, well, you could have a power of attorney and do that. Well, some powers of attorney, if they're more than 3 or 5 years old, not everybody will honor them. And if assets are transferred into a trust and there's a successor trustee named, then no one would have to have a guardianship of the estate. So you avoid that, and at the time of death, even though in Texas our probate system is streamlined and simpler than most states, you still have to do something. And with a trust, you don't have to do that at all. Some people also like a trust because they don't have their finances will not be disclosed in public, become part of the public record as they do with a will.
Okay.
So with a trust, to fund the trust and transfer everything in, it's a bigger job. There's more doing, and it's more costly. With a will, it's cheaper, less doing, and there's work to be done after the time of death. So my rule of thumb is when people ask which is better, well, it depends on your circumstances. And the older someone is, particularly when people are 65 and older, when the risk of incapacity is greater, I think it makes more sense to prepare a trust and have it fully funded and have the whole family involved in the process so they know what to happen if there's incapacity, and they don't have the risk of guardianship or have to deal with probate later on.
If you're younger, how we are, in our early 40s, would a will be something that you would recommend?
Yes, and it's a judgment call about a will or a trust at that time. Some people say, well, if someone becomes incapacitated, it's still a nightmare for them to have to go through a guardianship.
Right.
It's less likely, and wills cost less, so you may want to choose it for that. So it's a subjective call that's not a clear right or wrong, considering how streamlined Texas probate is.
Okay, great. Yeah. Thank you.